Today's date is April 5th. As I said, we're sitting at the University of Akron School of Law. I'm Judge Theodosi. I'll be presiding. I've mentioned my colleague Judge Carrs on my right, and Judge Sutton will be the panel for today. The first case that we are going to hear is Robinholt versus Wilson. I should say the only case due to unfortunate circumstances. We only have one case today. That's case number 21CA011782. Each party will be given 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. So, appellant, if you'll let me know how much time you wish to reserve, I'll interrupt you and let you know as you get close to that amount of time. These oral arguments are recorded and posted on the court's YouTube channel, so we ask that you refrain from using the names of any victims or children if applicable to the case. I can tell you that Judge Carr, Judge Sutton, and I have read the briefs in this matter and we're prepared to proceed. So I'll start by asking counsel, are you going to reserve any time for rebuttal?
Yes, Your Honor, I reserve 3 minutes.
3 minutes. I'll let you know as you get close.
Thank you.
All right, you may proceed. Thank you.
May it please the court, my name is Jeffrey Kruger. I represent the appellant Lynda Robinholt in this matter. The trial court erred as a matter of law when it granted summary judgment in favor of the appellee and dismissed the appellant's complaint on the basis of collateral estoppel or issue preclusion. The Ohio Supreme Court has recognized that the two terms are synonymous. I'll try not to confuse them, but if I'm referring to collateral estoppel or issue preclusion, I'm referring to the same thing. Given that this is a summary judgment decision, the standard of review here is favor vote. The trial court erred in granting summary judgment in favor of the appellee on the basis of issue preclusion, where the prior action relied upon was not fully litigated. In fact, the matter which had its genesis in the County Probate Court had been dismissed on the merits of the complaint. A motion for sanctions was filed subsequent to the dismissal. The motion for sanctions was granted in part, but no monetary award had yet been made. At the time, a settlement was reached, and the motion for sanctions was dismissed or withdrawn, would be the proper terminology. As a result, there was never the essential element to invoke the doctrine of issue preclusion, and that being that the previous case was fully litigated to the extent there was a final appealable order. The lack of any award of sanctions has precluded there from being a final appealable order out of the County Probate matter. Now,
Counsel, as I understand it, what happened was that the complaint itself was voluntarily dismissed.
yes,
And then the motion for sanctions was filed and a hearing was held on that. But the hearing related solely to the sanctions issue.
in theory, yes.
Okay, all right. Now, and after the ruling, which obviously was against your client, then the court had not actually determined that the amount of fees, attorney fees.
That's correct, Your Honor. The court had reserved 2 issues, one being the allocation between Ms. Robinholt's counsel at that time and Ms. Robinholt of the sanctions, and the amount of fees. Those 2 issues were set for a subsequent hearing. Before that hearing was determined, or determination was rendered, that a settlement was reached so that no award of sanctions were ever issued against Ms. Robinholt. And
So I guess I want to ask you, I'm sorry. I guess I want to ask you if there had been, if the court had ruled after the first hearing on the sanctions and had allocated the fees and had set the amount of fees that were awarded, that would constitute a final bill order.
yes,
So
Had the court gone through and issued a monetary sanction? No, I would not be saying that. But we didn't get to that point.
So it's not so much, when you say fully litigated, it's not so much that the issue, what issues are raised in the hearing, sanctions hearing, but it relates more to the fact that there's a final order.
Correct.
Okay.
Yeah, you had to get to the point of there being a final appealable order. And without that, without an order of sanctions and the determination of an amount of the sanction, there was no final appealable order from which an appeal could have been taken. And as a result, everything was still interlocutory up until that point. It's also important to note that the probate court in its order did not include 54B language, which could have given rise to a right to appeal. The lack of those two things combined leads to a lack of a final appealable order, which is an essential element for collateral estoppel, issue preclusion, and/or res judicata, which they've raised. Further, while it is a matter of a motion for sanctions that was filed, but not a complaint, similar principles that the Supreme Court announced in Denham versus New Carlisle should apply. The fact that there were claims pending at the time of the dismissal or withdrawal of the sanctions motion resulted in the prior order becoming a nullity. In fact, the case law dealing with issues of motions is such that the withdrawal of a motion renders it as if the motion had never been filed. So in this instance, the fact that the appellee in the Cuyahoga County action withdrew their motion left it as though there had been no motion ever filed. The second issue we hear before is that the trial court abused its discretion when it denied appellant's motion to withdraw and/or amend her responses to appellant's request for admissions. In this instance, the responses were served 11 hours, less than 11 hours after their due time. The case law is replete that no formal motion requirement is required under Civil Rule 36B. In fact, the simple act of filing responses, even though late, has been repeatedly considered by courts to be a motion to withdraw the admissions under Civil Rule 36B. 36B looks at two-part standard. The first, will the presentation of the merits of the action be subserved by allowing withdrawal or amendment of the deemed admissions? In this case, the answer to that is yes. Second standard is that the party who obtained the admissions fails to satisfy the court that the withdrawal or amendment will prejudice the party in maintaining its action or defense on the merits. Again, that element here was also satisfied. The court knew of the withdrawal of the request for admissions, and in fact, the appellee's counsel knew that the requests were going to be slightly delayed. They were served by 10, I think it was 37 the next morning, because of some technical and other glitches. They were supplemented 2 days later, and they were revised, yet were supplemented a second time as well, all of which are sufficient to constitute a motion to withdraw the deemed admissions.
But counsel, it wasn't just that they were untimely filed, right? It was the issue of whether or not they were adequately answered.
No, Your Honor, that issue was never presented to the trial court. There was no issue ever raised to the trial court as to whether the admissions themselves had adequately or not adequately been answered. The appellee's sole position was not with regard to the request for admissions, Your Honor. The motion to compel related to interrogatories and production requests, but not the admissions. The appellee's sole position was they were 11 hours late, therefore they deemed admitted, no need to pursue anything further. Thank you. prejudice is demonstrated by a number of factors here. One, the requests or the responses to the admissions were presented actually faster than if they had been mailed on the day they were due, because they were sent by email. If they had been mailed out on the 11th of August, there would have been 3 days for mailing. They could have been received by the 13th. They would have been timely. Here, they were sent by email at 10:37 on the 12th. That time frame was 9 months prior to the appellate taking the appellant's deposition, 10 months prior to the discovery cutoff in this case, and 11 months prior to the trial date. Yet this court, the trial court specifically addressed the admissions issues at page 10 of its decision and again at page 12, and refused to allow the admissions to be withdrawn. For the reasons stated, Your Honor, appellant respectfully requests that the court sustain its first assignment of error, vacate the trial court's July 16, 2021 journal entry and decision to the extent it granted summary judgment in favor of the appellee and dismiss the appellant's complaint, and remand the matter to the trial court for further proceeding. Further, with regard to the second assignment of error, the appellant requests that the court sustain the second assignment of error, remand the matter back to the trial court for further proceedings, with instructions that the appellant be permitted to withdraw and or amend the deemed admissions. If you have any further questions, Your Honor, I have to take them, otherwise I will reserve my time for the
Good stuff. All right, there's not any other questions. Thank you.
Thank you.
You'll have your, actually, you'll have 4 minutes and 20 seconds if you'd like to use it for rebuttal.
Thank you, Your Honor.
Counsel, you want 15 minutes then?
Thank you. May it please the court, my name is Michael Wilson. I represent the appellees, Robert D. Wilson, in his capacity as successor trustee and in his personal capacity. Today we're dealing with a fundamentally frivolous case. The Cuyahoga County Probate Court held appellant plaintiff Robinholt's claims to be frivolous and sanctioned. Her former attorneys paid my client $30,000 for this frivolous and sanctionable conduct in that case. Yet, despite having been held to have asserted claims with no basis in law or fact, Robinholt literally filed the same frivolous claims again in a different form with new counsel in this case. This case should have never been filed. Now the parties are before this court arguing the moot and defective appeal regarding claims previously determined to be frivolous. While the trial court's decision can certainly be upheld on the merits, such an inquiry is not even necessary as Robinholt's appeal is fundamentally flawed procedurally. The trial court's judgment entry is 18 pages long, reasoned opinion. The order of the trial court consists of the entirety of these 18 pages. Despite this, Robinholt ignores the vast majority of this 18 pages, explaining in detail the many defects of her claims to only address a single issue for review, being whether issue preclusion attaches to the February 22nd, 2018 sanctions judgment entry from the prior lawsuit. To say that the trial court order was only decided on issue preclusion based upon the prior sanctions judgment entry is illogical on the face of the order. Most blatantly,
Excuse me, could you repeat that again?
it's illogical on the face of the order. Most blatantly, it's shown by Robinholt's claim for reporting of the trust assets, which she incorrectly calls an accounting. This accounting occurred approximately 10 months subsequent to the prior litigation. It was explicitly decided by the trial court on the undisputed facts in the record. Issue preclusion was completely uninvolved in the trial court's decision on this claim.
Counsel, let me stop you because you indicated that just by reading the trial court's opinion on its face, it's not just decided on the basis of issue preclusion.
Correct.
What do we do with the trial court saying in the very first paragraph, summary judgment is granted on the basis of issue preclusion? And then when it finishes, it concludes and says summary judgment is granted on the basis of issue preclusion.
That is one basis, and I would consider that a summary by the trial court. But the trial court did everyone a favor here by writing a very detailed, reasoned opinion here. And it clearly lays out in all the different sections why it's ruling particularly on each issue. What's done in a summary fashion is helpful guidance, but the entire order is the order of the court. It's also very important to note that Robinholt does not present any argument regarding her claim for an accounting in her briefing whatsoever. As I previously stated, the trial court gave multiple other reasons for dismissing all of Robinholt's claims beyond issue preclusion from the prior litigation. Even though issue preclusion was correctly applied by the trial court, Robinholt's utter failure to address the entirety of the trial court's order renders this appeal moot, as these arguments are now waived. It should be further noted, Robinholt never contested the findings of the trial court that her claims in the current case are the same as her claims as in the prior litigation. Similarly, it must be emphasized that Robinholt never addressed the application of res judicata in a special proceeding, such as the motion for sanctions in the prior litigation, in her briefings on summary judgment, or in her appellant briefs, despite this issue being specifically raised by Wilson on summary judgment. Robinholt attempts to address these issues for the first time in her reply brief on this appeal. A party who raises an argument in the court, who fails to raise an argument in the court below, waives her right to raise it on appeal. This court will not consider arguments that an appellant fails to raise in her appellant's brief, and these arguments cannot be raised later in a reply brief.
Of course, with the summary judgment standard and treasurer, it was your burden as a moving party to demonstrate that there was not a genuine issue of material fact before she even had a burden to respond.
Correct.
So what did you do to meet that burden?
I will explain here in further detail that what was done to meet that burden was that the complaints of the prior case and this case were put in a detailed charge and motion for summary judgment, comparing literally allegation to allegation and how they repeated the exact same things. And that a special proceeding is different from a litigation normal case in that it affects a substantial right in a special proceeding that is a final appeal of order. So that is why issue preclusion would apply to it.
However, do you agree that the issue still remains in regard to attorney fees and the allocation of the fees?
I think those are two separate issues. The substantial right was affected in the special proceeding as to determining that sanctions were to be found and that the case was frivolous. And that the attorney's fees are a separate issue. Even beyond that, the issue of attorney's fees was actually resolved. Her attorneys did pay $30,000 to resolve that issue in actually mediation before the Cuyahoga County Probate Court, where all the parties were there to have a hearing to determine those attorney's fees. So it was actually determined there in the courtroom. That's where the settlement came about.
But it was a settlement, it wasn't an order of the court.
It was a settlement, but it was finally determined at that time. So the position of the appellee is that it's a substantial right that's determined in a special proceeding, and that alone is enough. But regardless of that, it was definitively determined the dollar amount with the settlement, which Robinholt was not a party to.
So you're differentiating between the case law that says that you don't have a final appealable order until attorney fees are actually awarded by somehow saying that this was a substantial right in a special proceeding that maybe was not appealable or something? I'm not sure I'm following how that...
No, I'm saying that it was appealable at the time that it was determined that this that sanctions and frivolous conduct were found.
What do we do with the case law that says it's not appealable until the actual sum or the actual amount of attorney fees is awarded?
That case law was not raised by the appellant in any regard other than for reply. So that argument's been weighed by the appellant, and those issues are not before the court. But in any regard, I do think that there is a distinction here to be made that a substantial right in a special proceeding, because this was the jurisdiction, this was continuing jurisdiction of the court here. The 41A dismissal by Robinholt has absolutely no effect in this case because this was not a 41 dismissal here because there was not claims being dismissed. This was a special proceeding.
Thank you.
Moving forward with that point, that regardless of Robinholt's mootness appeal, issue preclusion was properly applied, the essential test of whether the doctrine of issue preclusion is to be applied is whether the party against whom prior judgment is being asserted had full representation, full fair opportunity to litigate the issue of the first action. A decision granting a motion for sanctions is a final appealable order as it affects a substantial right made in a special proceeding upon summary application in an action after judgment. In this case, a multi-day full evidentiary hearing was held, conducted in prior litigation. The same parties and the same issues were involved. After the issue of frivolous conduct was fully litigated, the probate court entered the sanctions judgment entry as to those orders. Again, the probate court found there to be no basis in law or fact for Robinholt's claims. As for Robinholt's appeal as to her deemed admissions, this court does not have jurisdiction at this time to review the corresponding discovery order because it is not a final appealable order. Discovery orders are interlocutory and generally not final or appealable. Robinholt has the burden of proof to show an exception to this rule. She has failed to do so. The only argument raised was that the trial court used the admissions to decide the motion for summary judgment. To qualify for this exception, Robinholt must show three things. One, the discovery order solely relates to the issues deciding the summary judgment. Two, absent the discovery order, summary judgment would not be granted. And three, summary judgment terminates the entire case as to the party seeking the appeal. Robinholt fails to satisfy any of these three requirements. The trial court order explicitly shows the admissions were not used by the trial court in deciding to dismiss Robinholt's claims on summary judgment. The admissions are only mentioned in passing regarding Wilson's counterclaims, which remain pending and undecided and not subject to this appeal. Even Robinholt argues that the decision on summary judgment was based solely on issue preclusion, not on the admissions.
But of course, you're arguing the opposite. You're arguing that there was a decision on the merits, not just on issue preclusion.
On certain issues, there were...
Doesn't that cut into your argument as to why this is not a final appealable order?
No, it doesn't, because it would have to be used, these admissions would have to be used to decide on the merits. If you look at the trial court's order, things that are decided on the merits, for example, like that counting, the trial court looked at the reports provided by my client and determined that they satisfy the law. That has nothing to do with the admissions. And if you look at the trial court's order, the only way that the admissions are used are in discussing whether to grant summary judgment on my client's claims, the counterclaims, which the trial court ultimately decided not to grant and left those to be tried by a jury. Since the discovery order is not appealable at this time, Robinholt's appeal fails as a matter of law to this issue without any need to examine the merits. However, the merits of the discovery order are equally against Robinholt. She has the burden to prove that the discovery order was an abuse of discretion. Abuse of discretion means that it is arbitrary, capricious, and unreasonable. The record shows the trial court had ample reasonable grounds to deny Robinholt's motion to withdraw her deemed admissions. Wilson detailed an extensive history of Robinholt's discovery abuses by being non-responsive and uncooperative.
Counsel,
Yes.
then do you disagree with the opposing counsel's characterization that the sole position was the admissions were 11 hours late?
No, I completely disagree with him. And counsel has misrepresented the record. He said whether the answers were adequate was never presented to the trial court. That was actually presented in full briefing to the trial court twice. They made a motion to withdraw the deemed admissions, and in the response, these arguments were specifically raised by my client. And then they made a motion for reconsideration on the motion to withdraw deemed admissions, and the same arguments were brought up again, showing that these requests for admissions have never been answered. And it specifically stated in those motions, responses, that my client would seek again another motion to compel based on the same reasoning from the prior motions to compel that were granted by the court.
Got about 2 minutes.
Telling me Robinholt denying the dispute or even respond to Wilson's briefing on her abuses in the trial court. This is all reflected on the record. 6 discovery motions were granted against Robinholt, including motions for failing or refusing to timely respond to discovery 3 times, even though the court ordered her twice to do so. The motion to withdraw her deemed admissions was unnecessarily filed 6 months after failing to timely respond, even though the discovery deficiency letter was sent by my client informing that these were now deemed admitted at the time. Wilson followed the civil rules and was justified in relying upon Robinholt's admissions and should not be prejudiced by that reliance. Moreover, the motion to withdraw her deemed admissions was devoid of any evidence and did not offer any justifiable excuse for a failure to timely respond. And most importantly, as I previously stated, Robinholt never actually answered the request for admissions in her late responses. She provided the same boilerplate objections that were already rejected twice by the trial court. If Robinholt's so-called answers were allowed, another motion to compel would be filed, and presumably would be granted, and discovery would be reopened and duplicated. The trial court has discretion to manage discovery and properly uses discretion in denying the motion to withdraw the deemed admissions. They had plenty of reasoning to do so, and it's not arbitrary, capricious, or unreasonable. Ultimately, the underlying case should have never been filed once, but certainly not twice. The refiling of deciding the frivolous claims with no basis in law and fact, and a facially defective appeal is an utter waste of judicial resources. The appeal is moot as Robinholt fails to argue or even address the vast majority of the trial court decision. The discovery order is not a final appeal order. This court does not need to evaluate this case beyond its procedural flaws. But regardless, the merits show Robinholt's claims are frivolous, sanctionable, and the trial court acted reasonably within its discretion.
Counsel, with that, you are out of time.
Thank you.
Thank you for your. I show 4 minutes and 19 seconds for rebuttal time.
I'll try to adhere to that or a little less, Your Honor. If I may address a couple points. Number 1, this court in Robinson v. Robinson, 2003, Ohio 5049, paragraph 6, stated that an award of this sanction is not final until the amount of the sanction is determined. Now, appellee claims that it wasn't raised by appellants. I refer you to page 2 of the reply brief. Quoted, quote, an award of the sanction is not final until the amount of the sanction is determined. Citing In re SP out of the 11th District and also citing Robinson out of this court.
Well, I think counsel was referring to the fact that you didn't raise it in your response to summary judgment, maybe.
I believe it was raised, Your Honor, but it doesn't change the nature of there being a lack of a final appeal order, which was raised in the summary judgment motion. Secondly, this court, it's important to look at the exact language used by the trial court. Under the heading decision, the trial court expressly states, and I quote, no genuine issue as any material fact remains to be litigated with respect to plaintiff's complaint. Defendants are entitled to judgment as a matter of law, and plaintiff's complaint is dismissed inasmuch as it appears from the evidence, in view of such evidence most strongly in favor of plaintiff, that reasonable minds can come to but one conclusion, that plaintiff is collaterally stopped from asserting her complaint in a different county against the same defendants on substantially the same facts. The whole basis of the trial court's decision is collateral estoppel. It's referred to, or issue preclusion. It's referred to there, it's referred to at the beginning of the opinion, as Judge Carr noted. It's referred to again on page 7, page 3, page 11.
Counsel, let me just ask you maybe one more question. The appellee here is indicating that you're not really contesting that these were the same facts, the same issues, the same claims that were raised in the County lawsuit.
Your Honor, I don't think the county court had any basis to determine that. The voluntary dismissal of the Cuyahoga County case rendered it a nullity. And as such, it's as if the complaint had never been filed. So there's really nothing to compare it to, because the Cuyahoga County case under Civil Rule 41A, with its voluntary dismissal, was rendered a nullity. There was nothing to compare it to.
Well, nonetheless, there was sanctions, whether it was a final order or not. Your client and her previous attorney were sanctioned by the California Probate Court. So I guess my question to you is that not a concern if they're the same issues, that there'll be another award of sanctions and maybe a lot more this time?
It's certainly something that may have to be dealt with, but it's not an issue before this court. It's an issue for the trial court to consider if and when it is ever brought before the trial court. Finally, Your Honor, the discovery order is an appealable order in this instance. As noted at page 10 of the trial court's order, the judge goes into a recitation of the motion to withdraw, the determination of the motion to withdraw, ruling on the motion for reconsideration, and then the 54B language set forth in the court's opinion specifically states that pursuant to Civil Rule 54B, this court enters final judgment as to the issue decided herein. And part of the issue decided herein is the vacation, or whether to allow amendment or withdrawal of the deemed additions. So it is clearly within the four corners of the trial court's rule. For these reasons, we would ask that the trial court's order be vacated and the proceedings be remanded to the trial court for proceedings consistent with that, and the complaint be reinstituted, and also that the trial court be instructed to allow withdrawal and or amendment of the deemed additions. Thank you.
Thank you, counsel. Thank you both for your presentations and arguments today. The court will take the matter under advisement and issue a decision in due course. We also, again, Judge Carr and Judge Sutton, want to thank you for agreeing to argue here at the law school. The clerk of courts will issue you a copy of the decision on the day it's released, and you both know that you can check the Ohio Supreme Court's website, where our opinions are also posted there. This being the only case will be adjourned until April 7th.